Hello, and welcome to the final lecture on the courts. We are going to talk about judicial review and policymaking. You saw the video on Marbury versus Madison that laid out the sort of specific instance where the court laid out its own power to determine what the Constitution says. And that's how we think about the power of the courts. Now, this is not just something that they invented for themselves in Marbury. There's a lot of evidence that this was the expectation of how the courts would work. And Alexander Hamilton wrote in Federalist 55 about this power of judicial review to determine constitutionality of laws. But Marbury is the place where it becomes the most obvious, where the principle is stated and it sort of plays out in real time. So judicial review is the power of the courts to determine the constitutionality of laws. And this is all federal courts, not just the Supreme Court. Now, the Supreme Court, of course, has the last say, but if they choose not to take a case, then the ruling of the lower federal appeals court stands in terms of the interpretation of the Constitution. Now, the expectation is, of course, that appeals court or the lower federal court has followed the existing precedent set by the Supreme Court. But this is why lower courts can declare certain things to be constitutional, and those rulings stand until the Supreme Court decides. Also, we can think of this in some ways as like an ultimate check over the other two branches, but that they're the ones who get to say what the Constitution means. But remember that the court can only go as far as its institutional legitimacy will allow. So it's not going to use that power unwisely, or at least generally speaking, it has not. And it cannot enforce its own decisions. The executive branch has to be willing to enforce the decisions. And Congress can change the Constitution, or Congress can set the process in motion to change the Constitution. So what we know is that this process of judicial review has looked different over time in our system. Why? Well, we can think about this as there being sort of historical eras of the kinds of things that the court was talking about, or the kinds of issues that it's more generally deciding. And so when we start thinking about that, the first historical era is really about the relationship between the national government and the state governments. What's federalism, right? What does it mean for states and the national government to share sovereignty? And this period of time is really from the founding to the Civil War. And it will make sense to you when we think about the fact that the court, particularly in the 1850s, is making a lot of decisions about slavery, which is inherently, at that time, a conflict between the national policy and individual state policies. Really, the bottom line question here is, what is the power of the national government? And what is the power of the states in relation to it? Now, in general, the courts rule in favor of national power, but that's not always true. Obviously, our previous discussions about cases in the 1850s, such as the Dred Scott decision, was clearly a case of protecting state power. But across the board, during that time period, those were the deep questions that the court was deciding. Now, the Civil War changed an enormous amount about our country, but one of the biggest things in the context of the law and of the role of the Constitution in our system was it sort of answered the question forever about which sovereignty is supreme, and that's the national government, right? So that states cannot secede, states cannot de-ratify the Constitution, and that the requirement is always that the state and federal government solve their problem as opposed to just breaking apart. So after the Civil War, we really moved to a conversation about the economic powers of the federal government, right? So if the federal government has powers over the states, what kind of economic control is the federal government allowed to have? How much can the government do? And so during this whole time period, right, we think about this as in the very end of this period, right, we think about the Great Depression and the exercises of power by Franklin Roosevelt to try to get the country out of the Great Depression. But this conversation about economic control was going on through this whole period. So earlier in the 20th century, when Teddy Roosevelt was president, right, he was trying to break down these sort of large monopolies in particular industries. And lots of progressive era labor laws came before the Supreme Court, such as child labor laws and hours per week and overtime laws and conditions of working and all this kind of stuff. So this sort of economic control and the power that the national government has to tell the states and to tell businesses and individuals how they can behave, this is really what's going on through this whole entire period. Now, the New Deal is really the biggest piece of this, because it's probably the time when the federal government, particularly through the executive branch, worked the hardest or used the powers as far as they possibly could in an economic sense, right? Basically to try to give people jobs, to try to increase the social welfare spending and the safety net. And one of the things that we don't talk about a lot, mostly because it gets overshadowed by the beginning of World War II, is that by the late 1930s, the Supreme Court had invalidated quite a few of the federal programs that Roosevelt had put into place, basically saying that the executive branch did not have the power to do these things. Now, later on, after World War II, there's a bunch of changes that Congress makes to the laws that make it possible for the executive branch to do things like try to increase jobs and to have there be more federal employees and things like that. But the court initially said, no, that's not constitutional because that's Congress's role. All right, so the thing is that once again, World War II sort of changed our system in some really important ways, right? So not only did the experience of fighting World War II and the economic benefits actually to us of fighting World War II happen, but because World War II ended and we immediately began conflict with the Soviet Union and the Cold War, it sort of shifts the expectation or shifts the questions away from economic issues, which had largely been worked out in terms of war production and sort of figuring out how to operate the country after the war. We start talking more and more about civil rights and civil liberties, and that's really what World War II to the present has been about. So this is a great great graphic that demonstrates this, right? That after World War II, we start talking a lot more about civil liberties and civil rights. Now, I would say since the 1990s, in the last 25 to 30 years, we've moved on to talk in some ways just as much about civil rights and liberties, but there has been an increase in conversations about economic control and even federalism questions, the relationship between the federal government and the states, as our government takes on more and more different responsibilities and how to deal with things like homeland security, right? What's the national government's responsibility to the states in that kind of situation? So there have been more and more cases like that. But if we talk about the period between basically World War II and up to the present, generally speaking, we've been talking, the court has made many more of its decisions about things that are linked to civil rights and civil liberties. So all of the school desegregation and other kinds of business desegregation cases that went through through the Supreme Court, things like the rights of the accused that we talked about earlier, the increase in the Miranda warnings. And in fact, the court today even decided a civil rights and liberties case where it held that that for serious crimes, so basically for murder, for death penalty situations, but even for life imprisonment situations, that the jury has to be unanimous, that it has to be a unanimous decision to convict somebody of of a serious crime. So we continue to have decisions about civil rights and civil liberties. A lot of these ends up being questions about individualism, right? To what degree are individuals or people free to do whatever they want? And so those have been the kind of decisions that have governed things like same-sex relationships, not just Obergefell, which legalized same-sex marriage, but earlier kinds of cases like that decriminalized homosexual behavior and things like that. So many of these decisions have been about what are individuals' rights, what are the limits to individuals' right, and the bottom line is, what does freedom actually mean? And so in some ways, this takes us all the way back around to the very beginning of our course, where we talked about the ideas of positive freedom and negative freedom, right? So we talk about negative freedom as being enshrined in our civil liberties in the first and in the Bill of Rights in the First Amendment. But what do those actually mean, and how do those freedoms get appropriately appropriately protected for everybody in our system? So that's really how we can think about judicial policymaking, in the sense that while most judges have a legal philosophy, a set of legal policy preferences, at the end of the day, the court is a reactive institution. It can only make decisions about cases that are brought to it. They can't decide on their own, oh, we're going to talk about this. Right? They have to respond to the questions, the legal questions that are being brought up in the lower courts.